on YouTube. It is Tuesday, April 20th, 5:03 p.m. Eastern Time. And Ben, what were you going to tell us about?
What was I going to tell you about? You had a monologue.
Oh, I thought you were going to have some type of thing that you were going to talk about first. No?
Oh, no, not at all. I was just going to, I had a good line, a good intro line for Jameel, but wait till you get to Jameel, okay. And then I'll do my intro line, which will now be a total letdown because, we've kind of built it up into something.
Of course. Well, we that's what we're all about here at In Lieu of Fun. So, is letting people down. I was going to say that I had my first Zoom bomb experience in over a year. I had a good friend of John's, who's by default become a friend of ours, who's in London. It was his 40th birthday today, and a bunch of John's friends wanted to get together, and they organized this with all of the partners and everything, and so. From Montana to to Norway to London, it was all these time zones and craziness. And so to make it the most accessible thing possible, I was the only one with an institutional Zoom account that could have an over 30-minute meeting for free. And so I just created a Zoom meeting on my Cornell account and set this up. And I was like, I'm going to be in class. You guys are just going to have to go and have this meeting. And I set it up as a personal room or whatever. Well, apparently the gunners in my Cornell tech class saw that I had created an all caps Kate's personal meeting room, created this new room and thought that it was my office hours. And so Zoom bombed for 2.5 hours. 6 or 7 people kept showing up to this meeting, and all of my friends from all of my partner's friends from are having a 40th birthday party in this Zoom room across the entire world, and I'm teaching property law, and my Cornell students are just showing up in this room and being where am I, what's going on? Anyways,
that is excellent.
It was kind of a disaster.
So they weren't really Zoom bombing. They were showing up for office hours.
But I don't have office hours except by schedule, so I actually don't understand what they thought was going to happen. So anyways, it was just a funny. I was they wrote me all these apology emails. I was it's not a big deal. Whatever. Anyways, it ended up being very funny and everyone enjoyed it very much. But we are not allowed to have. Ben, do you want to do the intro?
Look, that is perfect evidence that we are not allowed to have fun anymore. But we are allowed to have Jameel Jaffer, enemy of the state, friend of the show. That was the line. That was the line. I thought, it was going to be, if it was impromptu, people would have thought it was a good line. As it is, I'm going to pour myself more of this Japanese whiskey, and turn it back to Kate.
So, Jameel, it's so great to see you again on the show, and in general. I've been dying. Yeah. Those who are not familiar with Jameel worked for many years with the ACLU doing national security work and First Amendment work, but primarily national security, I think. And then he became the director, I think, was it 5 or 6 years ago? How old are you guys? 5?
5 years,
6?
Yeah.
5 years. 5 years ago, became the director of the Knight Institute for the First Amendment at Columbia University, which is this awesome organization, and the organization that brought the suit Knight Institute v. Trump that we are going to discuss the concurrence today. The name changed to Knight Institute v. Biden, so now I feel weird talking about it like that. Also, do you feel weird that it changed?
I don't call it that.
Well, yeah. Do you call it Knight Institute v. Trump?
Yes. Yeah. That's how. It was against Trump and in his official capacity, but for actions that really, were very the kinds of things that only Trump could do.
Yeah, totally. Are you watching the Chauvin trial? I hear it in the background. Are they calling?
Yeah, we're getting.
Oh, that's
getting some.
My New York Times in the background. I turned it off. Sorry.
Oh no, it's totally fine. I just didn't know. I didn't want to interrupt. I just felt like
So for those who don't know, according to the Greek chorus in the chat, Chauvin has been convicted on 3 counts, and the people should follow the chat for updates on this, because we're actually conducting a show, so it's hard to do both at the same time.
Yeah, sorry for the timing of it. I'm like, Alice is probably watching it right now, very closely, I assume.
Yeah, I think she's trying to drive and watch at the same time. It's probably not a great idea.
Yeah. So basically, I just dropped in the chat also the summary of the opinion that finally came out in the Supreme Court to read people into kind of the procedural history of the case. Jameel, you brought the case in the SDNY. In what year? Do you want to just walk us through it really quickly?
Summer of 2017 we brought it, and first we sent a letter to the White House to Trump saying we think that your practice of blocking critics on Twitter is unconstitutional because your Twitter account is being used as an extension of your office, and the account constitutes a public forum under First Amendment doctrine. And given those things, you can't constitutionally exclude people from the account based on viewpoint, which is what you're doing. And we sent that to the White House, and we're not at all sure what the reaction would be. There was no reaction, and so we ultimately filed suit. And we won in the district court and in the Court of Appeals. There was but
it was summary order in the Court of Appeals, right?
No, there was
sorry, it was not summary order.
It was a unanimous panel with a decision written by Judge Parker, but you're thinking about the en banc.
Yes, that is what I was thinking.
Yeah. So there was an effort to get the court to rehear it en banc, which the court rejected. But then it rejected over a dissent by Judge Park. And then the Trump administration took it to the Supreme Court. But while the case was pending before the Supreme Court, Twitter kicked Trump off the platform, and Americans kicked Trump out of the White House. And as a result, the case became moot. And
just to be clear, you don't disagree that it's moot, right?
No, I agree enthusiastically that the case became moot. The only question was,
what were the grounds for mootness? I thought that you disagreed with Trump's people because of the grounds of mootness. That's right.
So the Trump administration argued that the case had become moot because Trump was no longer president. It is a brief that they filed the night before Biden's inauguration.
Basically saying that he was a private citizen, so the First Amendment didn't apply to him.
Well, that's right. Yes, that's right. Arguing that because Trump was no longer president, he could no longer exclude people from a public forum.
Right.
Yeah, which is another way of saying what you just said. Yeah, and we agreed with the Trump administration that the case had become moot, but argued that it had become moot not because Trump had been kicked out of the White House, but because earlier Twitter had kicked Trump off its platform. And the only reason it matters, like why the case became moot, is because there's a somewhat obscure doctrine called the Munsingware doctrine. It's not obscure to Supreme Court practitioners, but to others it's obscure. And there is a rule that basically says when a case becomes moot, when it is pending before the Supreme Court's practice is going to be to vacate the decision below on the grounds that the party that was seeking the Supreme Court's intervention didn't get a full opportunity to litigate the case to the end. And who knows, maybe the court would have overturned it. That's the logic of it. But there's an exception where the party relying on mootness was himself the cause of the mootness. And so if you, make the case
that's
moot,
very interesting. Yeah.
If it's your fault that the case became moot, then you can't go to the court and say vacate the decision below.
You can't kill the defendant and then argue that the case is moot.
That's right. But that's essentially what the Trump administration, not essentially, that is analogous to what the Trump administration was doing here. But they won that particular procedural fight, and the Supreme Court, without opinion, vacated the decision below.
Okay, so that's,
Can I ask, wait, before we get to Clarence Thomas, because I want to, there's a temporal issue here. And if, Twitter kicks him off 2 weeks before he leaves office, or 10 days, or whatever it is, before he leaves office, if you're right that is a grounds for mootness, why did the case hang around for another 2 weeks? And, it seems to me it is moot because he's no longer on Twitter, particularly if you're strict about jurisdictional rules, as the Supreme Court majority supposedly is. You win on that point. And so why, given that 2 weeks earlier it's moot for a different reason, why did you not prevail on that point?
Yeah, I'm curious too.
Well, I don't know why we didn't prevail on that point. There's no reason.
Because they didn't issue an opinion. You had to divine this
that's
from
right.
the vacation.
There were 14 conferences. There were 14 conferences in this case, which is, it was obviously
for a moot case.
For a moot case,
exactly.
Yeah. The mootness was kind of overdetermined in this case. There were, multiple reasons for mootness, and one of those reasons was evident in November, right, of last year. And yet the court just held onto this case, and we weren't sure why the court was hanging onto the case. And even now, we're not entirely sure. I mean, one reason might have been that Thomas just wanted time to write his concurrence, which I know we're going to get to. Maybe there was disagreement about the Munsingware issue, or maybe there was a question whether anyone else would sign Thomas's concurrence, or maybe there was a question whether somebody else was going to write as well. I don't know. It could have been for many different reasons, but it was an unusual thing, or it seemed unusual to us anyway, that the court just kept conferencing on this case that everybody knew was moot.
Yeah. I mean, just for people who aren't aware, that is kind of weird. Like, it's just a lot of talking and a lot of the justices meeting in order to discuss a case that, like, basically it seems like they're going over kind of, as Jameel said, an overdetermined kind of like how to settle, if that's what they were discussing at all. Like, we don't even know.
Yeah. We don't actually even know if they were discussing. Like, all we know is it was scheduled for conference. It might have been, the briefs were distributed and nobody said a word about it, except at the first meeting and at the 14th, right? We don't know. It could have been
that they said at the first meeting, hey, he might lose in November. Why don't we hold this until we see whether we have to deal with it, right?
That's possible. And then maybe they said, we don't want, it's a somewhat unusual thing for the court to reject the petition by the Solicitor General. When the government petitions for cert, I don't know what the statistics are, but they have a relatively high success rate, and that's partly reflects a kind of respect by this, the respect that the Supreme Court has for the office of the presidency and for the for the executive branch. When the executive branch is asking the court to take a case, they're more likely to take it. Maybe the court felt, or some members of the court felt, that yes, this is obviously moot, but the Trump administration is asking us to take it, and it's better if we wait till Trump is out of office for us, and at that point we can reject the petition. But this is all total speculation. I have no idea. The only thing I know is that Thomas wrote a concurrence, and that leads me to think that maybe some of the delay was related to giving him time to write that opinion.
So just for those who do not know the law of jurisdiction and are asking about mootness, the Supreme Court or any court in the United States is really only allowed to hear a case when there is a live issue between two parties. So Jameel sues me over a concrete and an identifiable injury. That is a ripe matter that the courts are allowed to hear. If the premise of that case is that I'm the editor of Lawfare and lawfare ceases to exist for some reason, then there's no live controversy anymore, and jurisdiction for the case disappears.
Yeah,
and that's more or less what happened here.
Right. Unless you're seeking damages,
Unless you're seeking damages. I want to be clear, because you could always seek damages after the fact, like for whatever harm Ben did to you as editor-in-chief of Lawfare, even if he ceases to be the editor-in-chief of Lawfare.
And I just want to say that in my capacity as editor-in-chief of Lawfare, I've always treated Jameel with great respect, even when he said on the Lawfare podcast to one of my cubs, now Alan Rosenstein, that he's been spending too much time in the Lawfare clubhouse, which we almost named a supporters group after the Lawfare clubhouse. We didn't, but we almost did. So I have never mistreated Jameel and Micah, but it's just a hypothetical.
I might have had some kind of intellectual property claim against you to add to my lawsuit, Ben, if you had.
Note that we didn't use it.
So I want to get into the Thomas concurrence, because I also really, for those interested in kind of the precedential value of this, one of the things that I thought was interesting was, in vacating the lower opinion, it vacated the precedential value of the Second Circuit opinion as well. Right? I'm like getting that. I think that's correct, right? Yeah. Yeah. And but there have since been, it's like kind of that, not to moot the point, but there have been other circuits that have followed this exact kind of formulation since then, that it doesn't really matter that much that the Second Circuit vacates it.
Yeah, it's not even clear. Like, vacator is a really weird concept, because it definitely has real effect with respect to whether the decision, an appellate court's decision, is binding on the courts in the districts that the appellate court oversees, right? So that Second Circuit decision is no longer binding in the Southern District. But that Second Circuit decision was never binding outside the Second Circuit. And it remains,
Yet it was adopted. And
it's been adopted.
And you can still cite it. You just put in parentheses "vacated on other grounds."
Yeah, and it's a persuasive opinion. Other judges will read it and have read it and have come to the same conclusions. And I don't think that the Supreme Court's vacator is going to have any dramatic effect, or maybe any effect, on the development of the law in this area, because the ship has sailed. There are other. It's conceivable that at some point the Supreme Court will weigh in on the merits and, squash this entire project. But so many other courts are reaching the same conclusions that it seems less and less likely to me that the Supreme Court's going to go in a different direction when it actually takes place like this.
I just want to say, before we turn to Clarence Thomas's concurrence, which is a weird departure from the substance of the case, Jameel and I have been on opposite sides of a lot of issues, and we may talk about one of them later today. But
I wasn't aware that we disagreed about so many things. But okay,
I agree with that.
We've never disagreed about anything, Jameel. But this case was an enormous accomplishment, and to remember what this case did, go back to 2017, where for the first time in American history, the president is using a purely private channel of communication to make major policy announcements, to insult people, to harass people, and if he doesn't like you on that account, he just blocks you. And this has no precedent in anything in the history of the presidency, and exactly one group of people figured out a way to challenge it. And by challenge it, I don't mean legally, I mean at all. You can. People will have their opinions about the Second Circuit opinion. I happen to think it's right. But there is just no doubt that what you guys did with this litigation was at least posed the idea that there were limitations on how the president could use a purely private channel of communication to reach and exert power, and then claim the private nature of the channel as a way to exercise exclusive control over it, all the while also claiming that when he tweeted at somebody, "You're fired," or "This is policy," that represents the position of the United States. And so I think this litigation, in a really important way, established that, or at least asserted that, and to the extent that it's now vacated, okay, it doesn't formally establish it, but there's some good law in the Second Circuit that's not binding, but it's still very vibrant, that says, hey, it can be private or it can be the president, but it can't be both. And I think that's a really important thing that you guys made real.
Well, I'm glad to hear you say all that, Ben. Yeah, I think it's important too, not just because of Trump, but because of how many other public officials now use their social media accounts as their main way of communicating with their constituents, and how many government agencies use social media to communicate with the public. And we're only now kind of seeing how this principle plays out in those other contexts. But I think it's for a number of reasons. It's this principle means that public officials can't as easily be insulated from the criticism of their constituents. It means that dissenters don't get purged from the public square. And to some extent, it prevents these kinds of spaces from becoming, echo chambers. And yeah, so I'm proud of the case, and my colleagues Katie Fallow and Alex Ubdo in particular, deserve a lot of credit for all the work they did on it over a period of more than 4 years.
Alex and Katie are great, and I echo Ben wholly. Like, this was like, I've been so psyched. This litigation, it like solemn, it created a record, and it created obviously like an actual until recently a precedent, but it really just did create a record of what had happened, and it opened the door to a discussion about public forums and a discussion about private public spaces and private public individuals that we are like so overdue to be having, I think, as like a nation, and especially as people who are versed in the First Amendment. I think that this is something that we're overdue for. And I am loath to say it, but I guess apparently Clarence Thomas agrees with us, and is like actively soliciting people to bring more types of claims. So this brings us kind of to the 12-page concurrence that Thomas wrote, which was, to those not familiar, not signed by anyone else, just Thomas wrote this kind of 12-page one-off that was a little bit bizarre and all over the place. And it's not the first time. I think it's maybe the third time that he has in some way kind of like solicited opinions or solicited cases or urged people to file cases, which seems like a truly bizarre thing for like this, like for a Supreme Court justice to do, is to solicit
it's
cases.
Much more than three.
Really?
It may be three in this area, but he has a kind of trademark. I join the majority because this case is moot. I'm open to the argument that, all of First Amendment law is bullshit. I'm open to the argument in an appropriate case that Lochner was rightly decided.
Right.
He's done this 100 times, and it's kind of the creation of an op-ed and a signal to future litigants through, and I don't mean to suggest it's improper. He's not the only justice who does this. He does it a lot, and he does it in kind of flamboyant ways. But I do think it's many more than three. I mean, It's kind of a trademark at this point.
I think it's, but I meant in like this area. So like, I think he did it in Packingham. There was like another, but anyways, but there was, I'm just kind of curious. What did you make of this concurrence? Were you surprised by it? Like when it came out, to have any written anything written at all on the opinion?
Given how long the court had held on to the case, I guess we weren't surprised that there was an opinion. And those of us who were speculating about who might be writing, some of us thought that it was likely to be Thomas. But I actually think, I know that the opinion has got a lot of criticism from especially progressives. I think that there's a lot of smart stuff in that opinion. I think it's, I think that it's in some ways a really great opinion. I disagree with, Thomas says that Trump's Twitter account, it's true, looks a little bit like a public forum, but Trump's control over his Twitter account pales in comparison to Twitter's control over Trump's Twitter account. Then he concludes from that Trump's Twitter account is not in fact a public forum, or he suggests that maybe it's not in fact a public forum. And I obviously disagree with him on that particular point. And there's some other details in there that I think are wrong. I also disagree with the implicit premise of the opinion, which I think is that the social media companies are biased against conservative viewpoints, and I have not seen evidence of that. And to the contrary, to the extent there is evidence on that point, it I think leans in the other direction. But I think a lot of what he says about the power of the social media companies and the challenges that presents to democracy and possible ways of addressing it are all totally. I don't want to say that they're right. I don't know if they're ultimately right, but I think that they're reasonable things to say. And he's not the only one who is searching for a kind of framework in which to think about these questions. And he's not even the only one who's calling for the imposition of common carrier rules or public accommodation rules. There are a lot of other people out there, scholars on the left and right, who are calling for similar things or the same things. So I actually think it's a really useful contribution to the debate, even though I disagree with some aspects of it.
Yeah, I mean, I think that, like, to put it another way, or is that basically that okay, so here I took it into, like, I did take it to kind of be a really great and useful articulation from the bench, from the Supreme Court, of the collective lack of understanding about where to slot kind of the type of how we want to govern and regulate and understand and control and curb these spaces that are walking this insanely difficult line between public fora and private fora. And
right.
The
it's
idea,
not like Thomas is confused about something that all the rest of us have figured out. Like, right? We haven't figured it out.
Oh my God, I love that you say that. That's exactly right. And I'm like, so part of me is kind of like, well, welcome fucking Clarence Thomas to my brain for the last 6 years. Like, this is like, or for some of us last 12 or 15, like, people have been thinking about this for a long time. But I thought that the articulation brought power to kind of the issue as like an underlying issue.
I want to take a way less charitable view of this than either of you.
Okay, hold on one second. I do want to say, here's the really big takeaway I've been dying to talk about with you, Jameel, and like maybe we won't end up having time to do it justice here. But the like, he basically comes to, like, if you think of like basically the public-private divide becoming more and more solidified over time in First Amendment law. And then you kind of think of where we are now, where everything is this big gobbledygook and we have no idea what's public and what's private. That I feel like at the end, Thomas calls out two alternatives for how to understand under the First Amendment. There is one which is the common carrier doctrine, and then there is one is which the public accommodation doctrine. And I have been playing, like, because I'm the do property, like I have been playing in my head and researching the public accommodation doctrine for a while, and have like actually not written a paper because there is like I've been like, this could be something that the court decides is the best fit. And I could certainly make the argument the public accommodation is the best fit. But should we adhere so strictly to the First Amendment writ large that I want to shoehorn it and like jam it into this space of a like public accommodation so as to make it make sense to a bunch of justices? Or should we explode this entire notion? And that is also what I liked about the Thomas opinion. And so I just want to say that. So go ahead, Ben.
All right. I want to defend the conventional wisdom that the Thomas opinion is nuts. And here's why.
Nuts, there's like for different reasons, but go ahead.
Hang on. All right. If the Thomas opinion had been written by Justice Richard Posner, or for that matter, Justice Stephen Breyer, people who are, whatever their philosophical ideologies, basically pragmatists, I would agree with you completely. It's a thoughtful piece. What doctrine would work best for this given the functional role that it's playing? Hey, there's some interesting stuff back in the 19th century about common carriers. This is Clarence Thomas. He believes that stare decisis doesn't exist, at least in constitutional cases.
I don't believe stare decisis exists in constitutional cases.
No. But if you don't believe in that wrong decisions, you should respect them. And if you, by the way, also don't believe in anything other than the original understanding of whatever text you're operating on, he shouldn't be believing in the public forum doctrine at all. It's all judicially made up. Jameel gets to cite it. I get to cite it. He should be willing to start from scratch and say, in 1792, what would the founders have thought about Twitter? Who is he to make this argument? And in that context, the only issue goes back to the point that Jameel made earlier, which is this is a guy who is looking for a doctrine that can support that can redress his atmospheric sense that Twitter is discriminating against conservative positions. And he's willing to throw out everything he purportedly believes to write an op-ed about how we got to do something about Twitter discriminating against conservatives. And I don't see why, given who he is intellectually, I should take that seriously.
You're engaged in a different enterprise than I am. You're looking at this opinion and you're trying to judge Clarence Thomas's coherence as a jurist or his integrity.
Exactly.
Or is he hypocritical or not? I mean, you may be right about all those things. I don't really feel qualified to judge his motives or, no, I don't mean to suggest that nobody is. It's just that, I haven't thought enough about, why he wants this framework in place, except I do agree with you that he has some misconceptions about what the social media companies are doing with respect to conservative viewpoints. I also think you're probably right that there's inconsistency between, that's probably too charitable a word, inconsistency between what he says here and what he said in other cases. Yeah. But set all that aside, just look at the arguments, pretend that it was written by a different judge.
I don't doubt that there are significant merits that he's making an argument. He's making an argument that were it made by somebody who had, I think, intellectual standing to make the argument is not without, I ran at Lawfare a very similar argument by somebody else, and I thought it was worth running. Mm-hmm. So I actually think the argument has some merit. I'm just shocked that he would feel like it is appropriate for him to make this argument.
Ben, some people read stuff on lawfare and they just think, this is, I'm just going to dismiss this because it's coming from lawfare.
Yeah.
And
it's like about the weight that a concurrence from the Supreme Court holds. It's like
and I accept their right to do that. Speaking of which, you have another case that you have gotten together with another esteemed conservative to file or to ask the Supreme Court to review. Yeah. This one involving the FISA and public access to it. And I'm going to surprise you and say that I largely agree with your position in this litigation. Not entirely, but why don't you give the audience a little primer on this case, sure. And then we can talk about it.
I just put a link to it in the chat description of it in the Washington Post.
So first, I should have apologized at the beginning. I have these seasonal allergies, and so I'm feeling not in top form. But so this is a case we've been litigating in one way or another for more than 14 years. When I was at the ACLU, a few of us filed right of access motion in the Foreign Intelligence Surveillance Court. This was in 2007. Asking the court to recognize a First Amendment right of access, a public right of access to the court's significant opinions. And over the next 14...
What would that encompass, Jameel? Just for people, can you just explain what...
The different motions that we filed sought different things, but basically we were looking for opinions in which the court had interpreted FISA or the Constitution, FISA, the Foreign Intelligence Surveillance Act, or the Constitution. And over time, so one thing you need to understand about this, I guess I should have started with this, but so the Foreign Intelligence Surveillance Court, if you don't know, is a court that was set up by Congress in 1978, largely in response to the Church Committee report, which found that the intelligence agencies had engaged in all sorts of abuses that compromised individual liberties and democracy. And the creation of the Foreign Intelligence Surveillance Court was supposed to put some of the surveillance that the intelligence agencies engage in within judicial oversight or under judicial oversight. And it did. In its first years, the Foreign Intelligence Surveillance Court had a relatively narrow jurisdiction. It basically operated like an analog to ordinary federal courts that hear wiretap applications in criminal cases. So instead of the government going to an ordinary federal court in a criminal case and saying, we want to wiretap this particular person because we have probable cause to believe that he's engaged in wrongdoing of one kind or another, the government would go to the Foreign Intelligence Surveillance Court and say, we have probable cause to believe that this person is a foreign agent, meaning an agent of a foreign country or a foreign organization. And the court would grant or deny the surveillance application. So it's very similar to what goes on every day in ordinary criminal courts. But over time, the jurisdiction of the FISC, the Foreign Intelligence Surveillance Court, expanded quite dramatically. And the court began issuing opinions that gave the government the ability to engage in broad programs of surveillance. And a lot of that took place invisibly, invisibly to most Americans. The court meets in secret, generally allows only the government to appear before it, doesn't publish its opinions. And so all the surveillance that it was authorizing behind closed doors. And for the most part, it was invisible to us until Snowden disclosed what he disclosed in 2013. And so starting in 2007, because that was after the Bush administration's warrantless wiretapping program had been exposed and Congress was thinking about legislating to legislating to bring that program within statutory law. But beginning in 2007, we started filing these First Amendment right of access motions. And we were seeking opinions, a very long answer to your question, seeking opinions in which the court had interpreted FISA or interpreted the Constitution. And the court said no in many different ways over many years. And at various points, it said we didn't have standing to file a right of access motion, but then it changed its mind about that. Then when one decision reached the merits and said there's no First Amendment right of access here at all. And then later, it concluded that it didn't even have authority to reach the merits, didn't even have authority to answer the First Amendment question. It just didn't have jurisdiction to consider our motion at all. And that's sort of the state of the law right now. And we kind of hit the end of the road with the FISC and the Foreign Intelligence Surveillance Court of Review, which is an appeals court that oversees the FISC, last year. And what we filed a couple of days ago, yesterday, is effectively a cert petition asking the Supreme Court to intervene in this case. And in some ways, I suppose this is expected because, once you are at the end of the road in the appeals court, your next stop is often the Supreme Court. But one thing that makes this petition a little bit different is that it has on it not just the ACLU, which is the movement here, and lawyers from the ACLU, but also lawyers from the Knight Institute and the Yale Media Access Clinic, and Ted Olson, who is the former Solicitor General, and he was the Solicitor General under George W. Bush, and the head of OLC under Reagan, somebody who has a ton of credibility in many different circles that ACLU lawyers don't run in.
And who was the principal litigator in some of the cases that, on behalf of the Bush administration, in some of the cases that caused you guys to go into court and ask for a public right of access to this material.
He argued the first case before the Foreign Intelligence Surveillance Court of Review in 2002. It was the first time that court convened, and he argued the government's position in that case. So, obviously,
he's in addition to being a Solicitor General, he is one of the best known and most respected, I would say, litigators in the country. And he specifically came together with, oh my God, the name is totally escaping me, Obergefell, right? I thought that there was
David Boies.
Boies, yes, of course. Sorry, David Boies. To kind of push for legalization of gay marriage to the courts. But yeah, it does add some that's super interesting. I don't know if I'm allowed to ask how that came about, but it's super interesting.
Hey, you're allowed to ask it.
Okay.
And I'm allowed to answer. So Ted is a member of the Knight Institute's board. We have a 9-member board, and he is one of the members. Has been a member of the board for the last three years, at least, maybe 4 years at this point. And has been part of many discussions over the last few years about this particular project, and has been an enthusiastic supporter of it from the beginning. And I got to know Ted through the Knight Institute, but when we started thinking about how to present this to the Supreme Court, it seemed like I spoke with the ACLU lawyers, Patrick Toomey and Brett Kaufman, Charlie Hogel. They're at this point, there are a dozen lawyers on this, in this case. We all talked about it, and everybody thought that having Ted involved, he's counsel record, having him involved at this point would present the issue in the best possible way to the court. The point we're trying to make with his involvement, and this is obvious. You don't have to agree about the proper scope of government surveillance in order to agree that it makes sense for there to be a public right of access to the FISA Court's opinions. I'm sure that
It's a point of process, not of
disagrees with some
outcome.
of my views about surveillance.
Yeah.
But he's in enthusiastic agreement on this question of access.
Ben, what's your take?
So my take is gonna. If Jameel was spoiling for a fight about this, you're going to be disappointed.
I'm disappointed.
Look,
Ben. Disappointed.
Here's what I think. I think I agree with your argument as to the merits almost completely. It's been a while since I've looked at the public right of access to court proceeding cases, but I don't remember them as being court-specific. There's a public right of access, a First Amendment public right of access to the proceedings of courts, and it's a qualified right of access that gets balanced against lots of other things. But I'm not sure why it would be different in the FISC than it is the existence of the right would be different in the FISC than it is in the Richmond U.S. District Court for the Eastern District of Virginia. And now, how useful that public right of access is, given that courts, the consequence of it may be that you get a document that's essentially entirely redacted. I don't know. But in principle, I don't disagree with you that the same public right of access that affects every U.S. District Court in the world, in the country, implicates the FISC, and I'm a little bit perplexed as to how that can be in and of itself a controversial point. Furthermore, I agree with you entirely that the growth of the jurisdiction of the FISC, particularly in light of the passage of 702, which is this law that I support and Jameel hates, that allows the FISC to authorize programs of surveillance with respect to mostly platforms of the type that Kate studies. I think in light of that, the
That's
premium
a very
on this...
roundabout way of saying it. Ben.
I don't know that I
702. Yeah, 702 allows the court to approve, for example, the mass
programmatic surveillance,
Americans' international communications, huge programs of surveillance. The call records. Well, I guess the call records program was not under 702.
Yeah, it was not under 702. Right. Look, 702 is actually. Let's agree to bracket. We can have an argument about 702 anytime you like. I'm actually trying to agree with you here. Given 702, there is a policy engine dimension to the FISC that was not around 20 years ago that is around today, and so it puts a premium on the question. And I'm largely in agreement, or entirely in agreement, that is a important change that affects how important this question is. The problem I think you're going to have, and I'm not asking you to comment on this because asking a litigator to acknowledge the weakness in his case is always the wrong thing to do, and I'm not going to do it. I'm just going to assert that I think you actually do have a jurisdictional problem here, and that the better I agree that it creates a very weird arrangement, but it's not clear to me that the FISCer, the Court of Review, has jurisdiction over this question. I tend to agree that the FISC itself probably does, because there's a kind of inherent authority of the court to manage its own records. But it's not clear to me that the FISCer has jurisdiction over anything other than a denial of an application. And I worry on your behalf that the Supreme Court's attitude toward this thing is going to be, well, there's no conflict in the circuits, and so let's let Congress address Jameel's concern if it wants. That said, on the merits of the thing, I basically agree with you.
Yeah, I mean, I think that the jurisdictional point, I mean, even if you're right that the FISC statutory jurisdiction extends only to the denial of applications, it would still be very weird, right, for the FISC to have jurisdiction to consider this question, but the court that oversees the FISC not to have jurisdiction to consider the FISC's determination on that question. And then there's a
agree. It's very weird, but if you look at the statute, the FISC's jurisdiction is pretty narrow. And I just think if you're the Supreme Court and you want to avoid this, because the whole
there's many ways to, one prerogative being of the Supreme Court is that you don't have to explain yourself. So, if they want to deny the petition, they can deny the petition. But it's not like other circuits are going to come up with different solutions to this issue. There's only one channel here. It comes from the FISC into the FISCer and then up to the Supreme Court. That it's either the Supreme Court deals with it or the judiciary is basically saying we're done.
I agree with that, and I would not be sorry at all to see you prevail on this. I think it's an important issue. I don't like the idea of the development of a large body of law in secret, and that has happened. There is a significant body of law that exists only in dialogue between the National Security Division of the Justice Department and the FISC and the Senate and House Intelligence Committees. And that is not a healthy thing. And I do think sort of figuring out a way to be able to have those debates in public is super important. And I would love it if this were a vehicle to have some of that conversation. And by the way, if it doesn't have that effect because the Supreme Court hears it, I do think having Congress take a look at it and you've identified a real paradox here that is not like, that's weird as hell and that shouldn't be there, and calling some attention to it is a very healthy thing.
Yeah.
I'm
sorry if I've disappointed you twice by agreeing with you.
Yeah, next time, Ben, I'm going to get to agreement beforehand that we're going to have a fight over something, because this is like, it's the second time you've disappointed me.
Yeah.
I don't know what you just said, Ben, but you looked emphatic about agreeing to not agree with him. So
I said it's boring. We should go back to the Obama administration when we hated each other.
Everything. Yeah. We are running out of time, but we have two really great questions that first one is from Richard. Richard, please go ahead.
So, Jameel, this is fascinating, and I wanted to ask you though, just sort of the big picture. I know you worked for the ACLU for a long time, and so I'm curious how the mission of the Knight Institute differs from, and I presume complements that of the ACLU.
Yeah,
I thought this was super interesting, just because it directly kind of comes off of what we were just talking about, since you're now partnered kind of with the ACLU on this, and this has been a long-standing thing.
Yeah, I mean, we do a lot of work with the ACLU, so there's definitely overlap in our mandates and in what we do. But I think the emphasis is a little bit different. So we are an organization that's focused exclusively on free speech issues. Now, free speech broadly understood, but still free speech issues. Whereas the ACLU is a multi-issue organization at this point. We have a team of litigators who spend all their time thinking about mostly digital age free speech. We've just been talking about a non-digital age free speech question, but most of what we think about is sort of digital age free speech. And then we also have, since we're housed at Columbia, we have a research program as well. And the research program makes the Knight Institute a little bit different from other litigation organizations out there. We commission scholarly research, we host convenings, we have scholars visit us for long periods of time, and work on.
It's really a tremendously diverse institute, I would say. I love this aspect, and I think it's like, I think it's to be modeled, honestly. And you've walked the line really well, I think. And it was difficult.
Yeah, I mean, I love the research program too. I mean, in part because I was at the ACLU for so long, like I didn't really see this world, and to be honest, I wasn't, if you had asked me 6 or 7 years ago, like how much there was for me to, how much I would gain by spending a lot of time reading scholarly literature relating to the First Amendment, I probably would have said not very much. But that has not at all been my experience. Quite the opposite. I feel like having been immersed in the First Amendment scholarly literature has really changed the way I think about most of the First Amendment issues that I deal with day to day. And that's definitely been the experience of my colleagues too. So like having the research program and being, part of that community as well, that sort of academic community as well, really has had a big effect on, how we think about the issues that we're dealing with in the courts, how we prioritize cases, like which cases we really want to bring, and then how we prioritize arguments within those cases. I think, at least I am more conscious of the implications of following certain principles to extremes, and more conscious of the trade-offs between different ways of looking at things. And maybe that's really a comment on how myopic I was until 6 years ago, but it's really been a great thing for me.
That's lovely to hear. And is similarly, like, I don't know. I was like, I'm much younger and don't have as much experience by any means. Like, you've seen my entire career, Jameel. So, but I would say that, like, I've never been particularly, like, honestly, like, particularly, like, promise. I didn't feel a lot of promise through litigation. And I think a lot of the stuff that the Knight Institute has done has shown me, like, the inroads that, like, the right timed and the right poised kind of litigation can make, and how it's going to, just as a tool. And I think I maybe like that tool more than I like other tools even. Mike Godwin is here. If I can turn on his video. There you are. Hello, Mike Godwin.
Hi, Mike.
Oh, yeah. Hi, Jameel. How are you?
Good.
So my question really centers on the thing that struck me about Thomas's concurrence, which is that, he does some stuff that's fairly recent, and he cites Pruneyard, and which is what you'd expect.
I thought the Pruneyard site was super weird.
Yeah, it was a little weird from Justice Thomas, but we're not going to talk about what his character is. We just want to talk about the precedents. The thing that really was weird for me was when he went back to these 19th century public accommodation precedents. And the reason it was weird was that virtually all of our mass media law occurred after that. So, we didn't have, we only had, we had maybe common carrier status, not formally, even with the telephone and the telegraph. But it's not until you get to the 20th century that we have the grand bargain with AT&T and the government about common carrier status and regulated monopoly. And then we have the movies and television and radio and everything else. And also the bookstore case, which led Smith versus California, which leads to Times versus Sullivan. And so to me, the common thread that's interesting about Thomas is that it's like he wants to go back to the 19th century to preempt this whole structure of First Amendment mass media precedent that we've been building up for 100 years. And you have to go back that far. You have to go back before Theodore Vail, to really get to the idea that government has a prerogative to impose a kind of top-down common carrier status. So I wanted, I guess I wanted you to say what you thought about that, but also I think maybe your assessment about whether this strategy is going to be fertile ground for future opinions as people are trying to figure out how to regulate big tech.
Yeah.
Yeah. Well, you know a ton more about this than I do, so I'm a little bit reluctant to wade into it. But what I liked about his opinion is I think he's right that these companies have a lot of power over public discourse. I think he's right about that. And I think it's useful for a Supreme Court justice to recognize that so explicitly. And useful that it's coming from the right, because I think people on the left have been saying it. And once you recognize that, once you accept it, and maybe you don't, maybe you'll tell me that it's not true. But if you accept it, then you have to start thinking about what legal or policy framework makes sense in to help us kind of ensure that the power that those companies have is not entirely unmoored from the public interest. They use it in ways that's not entirely unmoored from the public.
The only thing that troubles me about that, I have no trouble with regulating any company, to be quite frank about it. But the thing that troubles me is that if this had been 15 years ago, we would be talking about regulating MySpace, which was the dominant social media company. And it's a little hard to say that Facebook and Twitter are going to be the incumbents forever, because history seems to suggest that they won't be.
Do you think that Facebook's power now is comparable to MySpace's power back then?
Oh, it's much stronger. I certainly agree that Facebook is a much more dominant incumbent than MySpace ever was.
But I will say, not to blow up Mike's point, I don't want to interrupt Mike, but just really briefly, think about AOL Time Warner and AOL's divestment of specifically the product breakup that was related to that merger of AOL divesting itself of AOL Instant Messenger and having to make that an open source thing. It turns out that no one goes to AOL and sits on a freaking terrible, spammy, full of ads, crappy service to just click through ads or to click through and get their news, or they come there to interact, to get their mail or to talk to their friends.
They use it as an ISP for
and if you spin it off that no one's going to keep coming, and it killed AOL. I mean, basically, it became a cloned service that people could offer as another product. And so I do wonder what on earth, I don't know. I'm with Mike. I'm not against regulating these companies necessarily. I just do not know that I'm just so scared of we submit to kind of I'm just so skeptical of the amount of vitriol we are throwing at them. It seems so
also,
it seems weird.
Also, so many more people say the words regulate the companies than articulate what regulations they would want to apply. And I'm totally cool with regulating the companies. Tell me what
All right.
Tell me what regulation you want to apply to what company.
Can I tell you?
Yeah, sure. In the Section 230, don't forget, that was part of the driver behind that was that conservatives wanted the new
pornography off.
To be able to take pornography off. They wanted to empower them to remove pornography.
What you have to recognize is that even the most milquetoast regulation. So imagine a regulation that just required the companies to be marginally more transparent about their content moderation practices or something like that. Totally milquetoast. All right. The companies, without some sort of larger framework like the Common Carrier Framework or public accommodation or some new framework, the companies are going to invoke the First Amendment as a kind of sword against that new regulation. And First Amendment doctrine, as it exists right now, actually gives the companies a lot of tools for that kind of challenge. And so
I think that's completely right, by the way. Completely agree. I completely agree with you. That the companies have more protection in the First Amendment than they've been willing to even rely on so far.
Well, so that's why if you don't find some new framework or old framework like a Common Carrier Framework or some other framework that changes the way that their First Amendment arguments are heard, then even the most milquetoast regulation is going to get struck down. And you see this with the Clearview case right now, and this is another show, but Clearview challenging the Illinois privacy law on First Amendment grounds, or Maine internet service providers challenging a privacy regulation on First Amendment grounds. It doesn't matter what the regulation is, because these companies deal with speech. they are going to take the First Amendment and use it as a hammer against whatever legislation comes along. That's why I find Thomas's opinion, at least, worth paying attention to, worth sort of taking seriously, because you have to come up with some larger structure to ensure that the First Amendment arguments that the companies end up making in this particular context, don't result in completely disabling legislatures from enacting regulation that is, in my view, necessary, and might be, in your view, necessary too.
Yeah. I think we're going to leave it there. We are over time, but we got all carried away, and then Mike Godwin got godfather of the internet, got us all worked up. So but thank you so much for coming on, Jameel. This was a sprawling conversation. Thanks for putting up with dueling Ben and me, although I'm surprised at how much we all agreed on, as it turned out. I was surprised to hear that you like the Thomas, or were intrigued by the Thomas opinion, I would say, in the same ways that I am, and kind of thought that there were good elements to it, and it wasn't quite as harebrained as everyone made it out to be. I mean, it is harebrained, but it's also it raises points that need to be made and need to be addressed. And I'm really excited to see what happens with the FISC. The FISC case and the right of entry. I'm sorry, I'm teaching property law right now, and yeah. You know exactly why my brain went there. I was I made the same mistake to Ben over text. But anyways, I'm so excited to see how that case comes out, and keep us apprised. We'll have to have you on to talk Clearview. Maybe we'll get Kashmir to come on, and that would be fun to kind of talk about
you should invite my colleague Ramya Krishnan on.
Ramya.
Yeah,
I would love to. Yeah, that would be great.
She's been spending more time thinking about Clearview than anyone else. So
cool. That would be awesome. We will be back 22 hours and 50 minutes from now. And until then, Ben,
we don't have fun anymore, but we do have multiple cases involving Jameel Jaffer that all, crash into each other at the same time. As though he'd planned it or something.
Yeah, it's pretty great. Actually, I love it. So I will see you guys soon.
All right.
Great to see you, Jameel.